50 WFTL in South Florida, and we are live on our YouTube channel, Condo, Craze, and HOAs. You want to go there so you can see Eric and myself. I'm Karen Curtis, and I'm here again today with attorney Eric Glazer from Glazer & Sachs, PA. Eric is board certified by the Florida Bar in condominium and planned development law, community association law. And he has a firm with attorneys in Fort Lauderdale and in Orlando. And we are here each week to answer all your calls and emails about the issues that make life in your condominium or HOA absolutely crazy from 1 minute to the next. And we'd love to get the phone lines going early or our YouTube chat box going early, answering all of your condo and HOA questions no matter where you are in the state, the country, or the world. We're international. Give us a call toll free right here in the studio, 877-850-8585. That's 877-850-8585. Or if you visit the Condo, Craze, and HOA's channel on YouTube, you can ask your question in that chat box.
All right. Good morning, everybody. And if you're a fan of the show, like Karen says, don't forget to do two things. Number one, subscribe to the Condo, Craze, and HOA's channel on YouTube. You can watch the show live, ask questions in the chat box, and watch any of our previous shows. And number two, of course, join our growing email list. By joining our email list, you can get announcements about the show, our blog, our free seminars. We'll talk about that in a little while. Our newsletters, updates on the law, and a lot more. And, of course, we do a blog every Monday morning, at hoa-condoblog.com. Again, hoa-condoblog.com. Tomorrow's topic, your legislative wish list. And we're going to talk about that a little bit today. And we'll start it off this way. You know, the Florida legislature will convene in March. So the next few months, I can tell you, will be chaotic. Here's how it works. Lobbyists are going to be walking the floors of the Capitol wanting to meet privately with legislators to explain why their proposed bill for their client is so important and that the legislators must have a chance to vote on it, again, for their client. You know, deals will be made, like if you support my bill, I'll support your bill. That happens all the time. And I got to tell you, having walked the halls of the Capitol with a lobbyist trying to get legislation done and having ducked into quite a few senators' offices and representative offices, it's an amazing experience, I got to tell you. I'll say this. People think, I'll contact my legislator and, we'll fight and we'll get this done. Let me put it this way. If you don't have an experienced lobbyist in your corner, you're not getting in the front door, Karen. That's how it works. The halls are filled with lobbyists, and they're the only ones that get to meet with the senators and representatives.
But wait a minute.
Period. End of story.
I thought they were representing the people.
Yeah. And you don't have a lobbyist, you're done. Okay. End of story. That's the truth. Because
a House member or senator files a bill, that doesn't mean that bill will ever be voted on, right?
Yeah, exactly. It doesn't mean that just because you file the bill, that's going to be have an actual vote.
Minor detail.
Yeah, when that bill gets filed, the House and the Senate leaders, they have to assign that bill to various committees, and it has to pass at each committee stop. It's called a committee stop. Now, suppose that bill, when it's filed, it never gets assigned by House leadership or Senate leadership to actual committees. The bill is dead on arrival, right?
Yeah.
It's dead because, again, it wasn't even assigned to one committee.
Yeah.
So that's how it works.
Wow. I mean, you still have not been able to get past what you was hoping is going to your legacy bill, which would be that they're requiring Well, no, you came close one time, but the wording was a little wrong.
Yeah.
And then the next time they just took it out for some reason
which
of
is
the
mandatory education we're talking about.
The mandatory education for both condominium and HOA board of directors. I mean, it's just silly. It's free.
Exactly. I really don't get why it won't pass. This year was perhaps the most important year ever in terms of new condominium laws, in light of the tragedy in Surfside. Mandatory reserves were passed, mandatory inspections were passed, and now directors could be held personally liable for failing to follow these new laws. Think about that. Directors could be personally liable. And what's the one thing that they take out of the bill? A mandatory educational course in order to get certified. It sounds insane, right?
Yeah, I mean, if you're personally liable, wouldn't you want to know everything there is to know about what's going on so you don't step in it?
Right. Yeah.
You know, I mean, so how are the directors going to learn about the new laws if there's no educational requirement?
Doesn't it sound silly? Right? Doesn't it sound nuts?
It's backward.
Instead, we have the same stupid situation in the state where you can get certified simply by swearing that you read your own governing documents.
But the new laws aren't in the governing documents.
I forgot about that. Right,
Yeah,
the new laws aren't there, right?
Oh my gosh, no. You learn nothing by reading your governing. You may learn how many board members are supposed to be on the board.
Right. But you don't learn about the new laws.
Or Kaufman language.
Right. But you don't learn about these new laws, and they can still get certified. That's how ridiculous it is. So, here's how the government apparently works. A director can be held personally liable for breaching laws that they're not required to know. Think about that. Does that not sound stupid?
Yes.
It sounds ridiculous, right?
I mean, so the easy fix is to require mandatory education for all board members, and that's what you teach in your education course.
Exactly. You'd say, why not, right? The classes are free. They're even offered on the internet. You don't even have to leave your home in some circumstances. I drafted the proposed legislation again this year, gave it to the powers that be, and I hope, that it passes. I certainly have my fingers crossed.
Are you in touch with Senator Daniel Perez? Wasn't he the one that pulled
next.
it?
He's next. There's other representatives and senators who I am in contact with.
I think he's going to be speaker.
He might be. Yes, correct.
Yeah.
Exactly.
So that
but,
you represent.
I hope the legislator or legislators who wanted it to die and won't put this through in the first place, I hope they take credit for doing so, and stand up if this bill doesn't go through, because it's hard to imagine.
Yeah, they have
frankly.
to own it,
Exactly.
And we heard last week that apparently the legislature does not want to address condo law again this year. They obviously did it last year, so we're one and done.
I get that. There's a lot of other things that need fixing besides condominiums, and condominiums took up a lot of time last year. I get that. We don't want to go down the condominium route again, right? A whole bunch of other problems in the state. But I got to tell you, this won't take much time at all.
No.
It won't even be debated, right? No legislator would be against it. It would pass without a hitch. So really, there's no reason not to take it up. But time will tell.
So if you're a lobbyist and you can get the ear of somebody and you like this idea, contact Eric.
Yeah, it's an easy one. That's how I see it.
Yeah. Whatever happened to HOAs being under the supervision of the DBPR? Is that ever going to happen?
And so many of our listeners want to know that, right?
What is that about?
Year after year. But in a word, no, there's just no stomach for expanding government overreach. It's dead. But even if that's dead, there's no reason why we can't fix the HOA statute, right? To kind of more mirror the condos in so many ways. For example, why does the condo statute require a website for 150 more units, but you can be 1,000-unit HOA, you don't have to put documents, official records on a website?
Why can't government be homogenous?
Yeah,
why can't they make it the same?
Here, there's certain things that should be homogenous. There's
Yeah.
no two ways about it. But again, for whatever reason, there's no stomach for any HOA legislation year after year after year. So HOA members keep suffering. But hey, let's ask our listeners, right? What legislation would you like to see the legislature pass and address this year? It doesn't have to be about HOAs, and condos. If it's something else, let us know. Just give us a call in the studio, 877-850-8585. Again, 877-850-8585. Or drop your question in the chat box on the Condo, Craze, and HOAs channel on YouTube. We'll be back right after this.
Oh no, an unexpected leak. Jay, you know that's no way to solve a roof problem. Call Best Roofing. We solve roof problems.
We are DMI Paving and Seal Coating, Florida's parking lot experts. We specialize in asphalt paving and repair, including pothole repair, seal coating using JC7 or polytar, concrete curbs, ramps, and walkways, and striping and pavement marking, as well as ADA compliance. We service commercial properties, including homeowners associations, apartment communities, shopping malls, warehouses, stadiums and arenas, and more. Experience is worth more than anything in an industry like ours, and our staff has decades of it. We have specialized equipment for any job, regardless of size, saving you time and money. DMI has a reputable history. We have been in business since 1956. We serve the state of Florida from 6 locations. Let us bid on your next parking lot project. Visit us online at dmipavingandsealcoating.com.
There are very large management companies and there are very small management companies, and I think Affinity sits somewhere in the middle of that, where they are big enough to provide you with all of the back of the house services, the accounting, the infrastructure, the support systems, but small enough to be high touch.
We believe at Affinity that we do the 9 to 5 so that you don't have to do that.
Eric Glazer. He is board certified in community association law. The phone lines are stacked, so if you're trying to call in, just be patient. 877-850-8585. Eric.
Hey, it's got a terrible thing happening in California. You just want to acknowledge it. Shooting in L.A., dance studio, 10 dead. It just doesn't stop one after the other. And our hearts go out to the victims of the tragedy and their families. On that note, let's go to Ted in Delray. How are you, Ted?
Good morning, Karen and Eric.
Good morning. How are you?
All right. All that politics makes your head spin with all
It
this
certainly
stuff,
does.
legislation and all that.
They just found documents that Biden has under Karen's butt. How did that get there? Oh, you're sitting on them. Oh, my God. DOJ is here investigating Karen's butt. It's terrible. All right.
If
Let's
I
go.
find any of the documents on the beach, I'll report.
Yeah, right.
Top secret.
A question for you. We have a situation in a condo where the painting is being done on the exterior of our clubhouse, but the community has not voted on it.
Oh, dear.
Is it? Well, painting is one thing. Are they changing the color?
Oh, yeah.
They're changing the color.
Oh,
They're changing
dear.
the color. Okay, so
So
it's a
what
common
response
element.
does the community have?
It has the option potentially to put a stop to it completely. Not only put a stop to it, but make them put it back to the color that it was. I don't know how many times I have to preach it on the show time and time again. If a condominium wants to make a material alteration to the common elements, bottom line, you need a unit owner vote. You have to do it in the manner that it's prescribed in your documents. Most documents...
Yeah, 2/3 it is.
Okay, it says in your documents 2/3?
Yes, even though the property manager is responding that it's a capital improvement.
No. I'm telling you, if you're changing the color, painting it would have been fine. Painting it would have been a normal repair. Painting and waterproofing, no problem, as long as you're putting it back to the same color. The fact that you're putting it back to a different color changes the game. It's now material alteration.
Yes.
And if you didn't get a vote of the unit owners, guess what? I drafted, that's my legislation. I drafted the legislation that added the words, you have to take the vote before the material alteration is made. So I got to tell you, if you don't get that vote first, you stand a substantial risk of having to put it back the way it was. And you have to pay for the job twice. It's horrible.
I have something weird, though.
Yeah.
So do we get legal to file something?
Absolutely.
Okay.
No two ways
All right.
about it,
Well, You'll be getting a call from us.
You got it. All right, thanks for the call.
I live
Appreciate it,
in
Ted.
a
Yeah.
condo,
Thank
but
you.
our grounds are governed by an HOA board.
Okay, that might be separate.
And then they painted the
Now
clubhouse gray, but we
That's
didn't.
different
See,
because
yeah.
that's a great point, Karen.
I just wanna bring that up.
Some common elements, and perhaps that's might be the point here, but he said it's his condominium that's doing it.
Oh.
But sometimes you'll have 4 or 5 condominiums that share a clubhouse, let's say.
Yeah.
And they form a separate corporation like an HOA to manage that clubhouse. And then that clubhouse can be painted a different color. It might not necessarily be considered a material alteration.
They don't have to take a vote in
Right,
an HOA?
exactly. In an HOA, they don't have to take a
Okay.
vote. That's exactly correct. Okay? Just it goes by how the documents, what powers the documents give the board. Okay? All right, let's go to the next call. Barry in Miami. How are you, Barry?
Barry!
Good. Hi, Karen. Hi, Eric. How are you?
What's going on?
First time call.
Yeah, first time call on my butt. Talking a lot about butts this
Yeah,
morning.
yeah, I see
But go ahead. Yeah. How's your butt, Barry? Go ahead.
Okay. In a condominium, if I make an official records request via email, is that a writing? Is that considered
Okay.
valid?
Great question. Okay. There's a case out there that says that it's not a writing. Okay. There's a case that says it's not a writing. But the problem is with it not being a writing, once your manager or once the board acknowledges that email, right, and says, okay, I've got your email. I understand it requests records. We're going to respond to it, right? And then you don't respond to it. The case went to arbitration, and the arbitrator said, hey, I'm not going to let you play the game of now saying it's not a writing, condominium association. Yes, if you would have ignored it, it wasn't a writing. But once you acknowledged it and you treated it as a writing and the unit owner relied on you, then we're going to say, yes, it became a writing and you had an obligation to give the unit owner access to records. When you didn't do so, you get fined the $500 and you lose attorney's fees and costs, etc. Hope that answers
Okay,
your question, Barry. Yeah.
That's the Humphrey versus Carriage Park case you're referring to?
There's a case in Aventura. I forgot the name of it. There's a case in an Aventura condo. No, it's not that. It's not the Humphreys case. It's a different case. I forgot the name of it.
What about the James Hantzman declaratory statement that dealt with emails between board directors, specifically
Right.
in the declaratory statement?
Very interesting.
They cited Black's Law Dictionary,
Yes.
which we both use.
Yep.
And they said, based on Black's Law Dictionary,
It's a
an
writing.
email is a right.
Right. So what do we have? We have the last
Does that
bunch of
change-
cases.
Does that change your answer?
No, I don't know if a declaratory statement. By the way, it's my understanding the arbitrators, they're not necessarily required to follow a declaratory statement by the division. It gets so complicated when these things happen. So Barry's saying, but wait a minute. There's a decision by the DBPR that says emails between board members, right? Can you get emails? Are emails official records? And all of a sudden, here comes a decision by the DBPR that says emails, we just said emails are not, that you don't have to respond to emails. But here's a decision by the DBPR that says emails are a writing. And since they are a writing, you're allowed to get these emails between board members. So Barry, and I know that the arbitrators themselves, they're not necessarily required to follow the decisions of the heads of the divisions in declaratory statements. So, I don't know. I think quite frankly, it's still up in the air, and it may require some sort of court decision at some point. What do you think, Barry?
Well, I think it was written by Siobhan Christian, who's the division head, and I would rely on something where it's not just written by any arbitrator. It's written by the division head, and I think you have to take that into account.
Right. Although there's no case law that supports that decision, right? Would you agree on that one?
I agree with you, but I think that's their current position.
Right.
I think an email request to request official records, if I were an association, I would not want to rely on, and Eric's right, before last January of 2020.
Commodore Plaza. It was a Commodore Plaza case, I think it was. Yeah, I'm sorry. Just came to my mind.
But I think now the division, if they say it's a writing for that purpose, they're not going to have different definitions of writing.
Right. Well, here's the problem, though. Here's the problem. If I send an email, right, How do I prove that you got it? How do I prove that you saw it?
There's a way.
How do I prove that you even had an obligation? See, the case law says there's no obligation of a director or the manager of the condo to read your emails.
But you can get an alert.
Right, you can get an alert. You can see if they did. So, you'd have to prove that they read. Suppose they never read it, Barry. Is it still a writing?
I don't think it matters. I think your argument is exactly the argument that was made in the case, that the director might not open the emails. The Hampton declaratory statement purely went to Black's Law Dictionary.
Right, but
looked at the definition of writing, and I think that's all they're going to look at now.
So you're saying so if we buy your argument, right? I'm just playing devil's advocate here. If we buy your argument, then the board and or the management company has an obligation now to have an email account and to timely review that email account basically every day and to respond. Doesn't say that in the statute. So I don't know how much I can agree with the declaratory statement, And, how can you hold the condo responsible if you can't prove that that email was actually read? But these are things, and these are things where you have, another position by the division that doesn't match the case law, and it just creates confusion. And ultimately, maybe, like I said, there has to be a court that has to rule on this very issue.
Well, it's hard to keep up
Barry,
with
like always, you keep our minds going all the time, and for that I appreciate it. You know what? What do people on the boards think? And for any managers out there, what do you think about a writing, an email being classified as a writing?
Well, it's hard to keep up with technology.
Yeah, but it puts a lot of pressure on that condominium association. Damn, I got to check my email box every day to make sure someone's not submitting a request for access to records by email. That's another obligation on me. Statute doesn't say that. So I don't know, Barry. It's a great question, but it certainly makes things harder for a condo association or a manager if we agree with that opinion. So, I don't know. I quite frankly, I like the arbitrator's opinions better than I like the declaratory statement. But Barry, great question like always. We got to keep moving on, though. How about Mark in Boca?
Mark.
Hey, how you doing?
How are you, Mark?
Good. I live in a small condo in Boca, and 2.5 years ago, I replaced my AC and the unit on the roof. However, the association won't let anybody go on the roof to make it up to code, and I'm stuck with an open permit.
So wait, who put it on to begin with? Who put that AC on the roof? Did you or the association? I didn't get it. A company of yours.
A professional company did.
Okay, so they go up, they pull a permit to go put it up there, right? And obviously, all AC units are required to be put on the roof. You have all rooftop units.
Yes, we do.
Okay. So yours is up there. A company pulls a permit, and after pulling the permit, the board says you can't go up there. You can't access your AC.
No, we can't raise it to what the code is now. It's sitting on the, the old style, the way they used to do it.
Right. Understand. So now it's supposed to be, on a little bit of a lift. I get it. I forgot what it's called, but it's not. And actually, it's better for the roof to not be touching it. But and the association won't let you do that because
they don't want anybody on the roof because they're worried about the warranty on the roof.
But then you need to close out your. Suppose everybody's air conditioner broke, so nobody's allowed to repair their air conditioner anymore or replace it.
No, you can repair it, but you got to sit there with an open permit while they figure it out. And my question is, would this affect the sale of my condo if I'm going to sell it?
It certainly might if you have an open permit. So what's going to happen when you try to sell your house? The title company is going to do a search of your unit, and in that search is going to come up your open permit. And they're going to say, wait a minute, before you sell your unit here, we got to get that permit closed. Right, because it's not something that the new buyer is going to want to take on, that obligation. So has the city, said you got to close the permit within a certain amount of time, or we're going to fine you?
I haven't heard anything, but 2.5 years is pretty long for them to resolve
I understand their theory about not wanting to do anything to the roof, but by repairing the AC or getting a closed permit or trying to close out the permit for the AC on the roof doesn't necessarily void the warranty. So I disagree with them. And again, they would let people on the roof to repair or replace. So why don't they let you close out your permit? Makes no sense to me. And yes, I don't think it's a reasonable rule. You certainly should be allowed to close out your permit. So because of that, I think if you went to arbitration, because it's not a reasonable rule, I think you would win. Certainly, you have to have the ability to close out your permit. End of story. Okay, done by a professional.
All right.
Okay, I think you win on that. All right, let's take our bottom of the hour break, everybody. Great phone calls. I see a lot of great texts coming in the chat box as well. We'll answer them when we get back. Taking your calls, 877-850-8585, 877-850-8585, or again, visit us in the chat box on the Condo, Craze, and HOAs channel on YouTube. We'll be back right after this.
Is your condominium or HOA in need of accounting services? Look no...
Welcome back to the second half hour of Condo, Craze, and HOAs here on 850 WFTL. Karen Curtis with attorney Eric Glazer. He's board certified in Community Association Law. There's a couple ways that you can get in touch with us. You can call Eric live on the show, 877-850-8585, or you can join our YouTube channel, Condo, Craze, and HOAs. You'll see us there and also be able to comment in the chat box. We answer both.
Hey, real quick, I just want to remind everybody, of course, that if you're a director, you have an obligation to get certified. If you don't get certified within 90 days of getting on the board, you're off. And I just want to remind everybody, our classes are coming up. Okay, real quick. February 7th, 2023, 2023, 8:30 a.m. in Broward.
Yeah, that's at the Signature Grand L&L Condo and HOA. And so February 22nd, 2023, 8 a.m., Palm Beach Convention Center.
Right, and February 28th, 2023, 8:30 a.m. in Tampa.
And then you reserve early by going to our website, condocrazeandhoas.com. It's all one word, no hyphens. And Eric teaches so many different topics, like the new laws that were just passed in his seminar. It's free. Anything about inspection and reserve funding laws that just got passed.
Yeah. Guys, this is the year. You really need to learn this.
Absolutely. Food is served. You walk away with a certificate that's frameable. The notes from what he tells you even as well. It's, support animals and emotional support animals, service animals, all of that, the documents that govern your condo or HOA. It's a really must-attend type thing. So how do they register?
Okay, just go to condocrazeandhoas.com. It's on our website. Couldn't be easier, okay? All right, let's go take some questions from the chat box. Renee writes in, if one person holds 2 seats, president and treasurer, do they get 2 votes? No, they do not get 2 votes. The president and treasurer are 2 officer positions, right? Officer positions. That person only holds 1 seat as a director, therefore they only get 1 vote. Annual election, what disqualifies a candidate? When is disqualification determined? Its disqualification is determined at the time that you have to submit your name to be a candidate. If you owe money, you're disqualified. If you have a previous felony conviction and your voting rights haven't been restored for the last 5 years, you are not qualified as well. Basically, that's the reasons why that you can't qualify to be a board member. Let's see. Who writes in? Here we go. Kathy. Is adding pickleball court markings to our tennis courts determined to be a material alteration? It would serve as both.
So it'd be tennis and pickleball.
And
it's a condo.
I've been asked this question so many times, and I think the question, it really boils down to what Kathy is saying. Are they just adding the markings so that it can serve as both, or they're really changing the court completely so that you can't play tennis there, or are they making it where you can have 2 different types of entertainment for the people? Look, I don't know if there's a case out there yet, but if I was the arbitrator, as long as you're keeping the markings for a tennis court and you're also allowing people to now play a game that's sweeping the country, I would say it's not a material alteration, okay? Let's go back to the phones. Bob in West Palm Beach.
Hello, Bob.
I hope you can help me sort of define my request. I'm trying to understand when the vote is made to fund or not fund the reserves, and what else do I need to get a copy of the reserve study that shows what's actually supposed to be taken out?
Okay, the board basically votes on whether or not to fully fund or to fund the reserve account at all at the budget meeting, and they base that vote on, wait a minute, did the owners previously vote to waive the full funding of reserves? If the owners previously voted to waive the full funding of reserve, let's say the owners were given the opportunity to vote and they voted for no reserves at all, or they voted for partial funding, right? Then the board at that budget meeting has to adopt the budget that those unit owners voted for. Does that make sense?
Yes.
Yeah. If the unit owners voted for no reserves, then at the budget meeting,
other votes could have been taken place.
I'm sorry, say that again?
I'm sorry, we don't know when that other vote could have taken place. I'm trying to zero in so I have a copy of the actual minutes, but it could have been any time during that year.
When the board sends out that budget meeting, they have under condo law, now if we're talking under condo law, they have an obligation only to send out a budget with fully funded reserves. Okay? Now, if they want to give the unit owners the opportunity to vote for something other than fully funded reserves, they can do that. So they can say, like, here's your proxy, right? We're going to have a budget meeting on March 10th at 7 o'clock to determine what budget we're going to adopt. And we're giving you several choices. Now, what you can also do is say, all right, since we're giving you several choices, we're going to have a meeting at 6:55, 5 minutes before. And we'll see how the votes went down, how the unit owners voted. And depending upon the votes at the 6:55 meeting, that will determine what type of budget we adopt at the 7 o'clock meeting. Okay? That's
Okay.
how it's done. That's the right way to do it. Okay?
So I can just request those particular budget meeting.
If you're a unit owner, you can absolutely request how the unit owners voted to waive reserves or not. And, of course, you can ask for the minutes of the board meeting, the minutes of the budget meeting, showing how the board members voted. Okay? Hope that answers your
thank you very
question.
much.
You
I
got it,
appreciate
Bob.
that.
How about Jake in Boca?
Hi, good morning, guys.
Hey, Jake, what's going on?
So, the answer your question that you put out to us is these governors we got from Rick Scott to DeSantis here,
Yeah.
they just keep letting more and more people build. So you ask what bothers you, this bothers me. They don't put any money in towards our schools, and we give them tax breaks. So it's very upsetting.
Right.
The roads are crowded, the schools are crowded, and they just don't care. They just want that tax break and come here.
I will
But
tell
that's
you,
my opinion.
I'm a DeSantis guy. I'll go on record as saying I'm a DeSantis guy, but there's something that also needs to be said about the rate of growth here. And the inability of our roads, like you say, to keep up with it, the inability of our schools to keep up with it. I agree with you, but a lot of that is controlled at the local level. I don't want to name cities, embarrass some cities, but there's certain cities here in South Florida that obviously allowed overgrowth. Obviously, where you can't drive in them when it's rush hour. It's ridiculous.
It is
actually,
bad.
to get
It's
to.
bad.
So that was done at the local level. So I'm not going to blame DeSantis for all that. But what's your question?
Okay, so there's 3 director seats up, and there's 4 people running. One of the 4 people, 2 of the 4 people were thrown off the board in past years, either voted off or just were removed from the board. So unfortunately, you know how it is, how hard it is to get people. Anyway, so one or both of the 2 people who are running, they spreading rumors that the board has been taking kickbacks and we're getting money, and the committee that was in charge of this one project is getting money. Is that a violation strong enough to have them removed from the balloting?
Never heard of board members being accused of kickbacks. Did you ever hear of anything like that?
No, this
Oh,
is
that's
the
new to
first
this
time,
show.
yeah.
It's amazing. So, no,
Groundbreaking.
the bottom line is that's not a reason to prevent somebody from running for the board. I just mentioned earlier what those, the way you can prevent somebody from running for the board from showing that they don't qualify.
Yes.
But accusing others of taking
Yes, I
kickbacks
heard
and
that.
stuff, no, that's been going around since condos have been built. Right, in like the 1400s.
Right,
Okay.
exactly. Out
Yeah.
of stone,
Yeah.
plumbing on the
Right.
outside.
So to follow up, just one follow up to that. Then I remember reading something at 720 about how we could censure a director. Can
Okay,
you tell me about that?
so if a director is accused of not disclosing, and it's in 718, not disclosing a conflict of interest. For example, I am the president of the board, and we are doing a construction contract, and I let my son-in-law appear in front of the board and do a presentation, and we wind up going with my son-in-law's construction company. I never disclosed this clear conflict of interest. So now, for the first time, quite frankly, the statute allows the board itself to remove another board member, but solely for failing to disclose a conflict of interest. That board member can shoot the other board members, and you still can't be removed. But if you fail to disclose a conflict of interest, then yes, the board members can remove that board member.
Well, until he's convicted of shooting and killing
right,
other
sure,
people.
right,
Yeah.
right, and then
But
it's
if
a
you're
different
charged,
story.
no problem.
Right now, you know what? I think
what
the
about
no,
censoring?
actually,
What
you have
about
to be hold on. You have to be arrested and charged with taking a kickback. Like you can shoot away, no
okay,
problem.
okay.
You know, I'm just making a
Oh, they
joke.
have
I'm
to-
just making
they
a
have
joke.
to arrest you
But
for it.
yeah, but it has to be a crime involving theft of funds, basically, and then you can be removed from the board.
So kickbacks aren't illegal.
Oh, they are. They certainly are illegal
But
under
that's
the
not-
statute. Yeah, if you're accused and arrested for taking a kickback,
Okay.
yeah, you're off the board.
Okay.
Okay, pending a determination of those charges. Okay.
Okay.
Hey, was it Jake, right? We got to take our final break of the hour.
Yes.
Taking your calls, 877-850-8585, or drop your questions in the chat box on the Condo Craze and HOAs channel on YouTube. We will be back right after this.
Is your home or condo looking?
Welcome back to the final segment of Condo Craze and HOAs here on 850 WFCL. Don't wait to the very end of the show to call in, because we run out of time and then you don't get your question answered. You can find us on the YouTube channel, Condo Craze and HOAs. Ask a question in the chat box or give us a call live, 877-850-8585. I'm Karen Curtis. That's Eric Glazer. He is a specialist in community association law.
Karen writes in with a good question. I'm a board member director. The condo is looking to get a social club liquor license. So you want to be able to serve liquor at your events. Need all 7 board members to get fingerprinted. What's my liability? Thank you. I can tell you that you want to get a liquor liability insurance policy.
Yes.
100%. And I will tell you, from what I understand, they're not expensive.
Oh.
Okay? And it will cover your association should anybody, get sued as a result of dispensing liquor at any social event. Definitely 100% talk to your current agent who's handling your insurance. Do not serve liquor. Again, do not serve liquor until you have this insurance policy in place. Okay, that's pretty important. A very important question that
I didn't know
asked.
you could do that.
Yeah, you can get a liquor license. Absolutely.
So they can't play mahjong. Remember the ladies that got arrested?
But they can serve liquor.
They can.
Right. Because the pot was exceeding $10, but drink away. All right, James in Fort Lauderdale. How are you?
Hey, how are you guys?
Okay, how can we help?
Okay, so I'm an engineer and a home inspector as well, and I had a client that lives in a condo. They just put in new impact windows. I had him saving $800 a year after the inspection. I was wondering, how can I contact someone on the board to get everybody saving this type of money in these hard times? Because $800 a year after year, is a lot of money.
So when you say they were saving $800 a year, they were saving $800 a year on what?
On their condo insurance or homeowners insurance.
Okay. So I can tell you that a lot of times it boils down to who has the obligation to maintain or install those windows. Because if the obligation falls on the association, then the association with just a board vote can put in all impact windows. Okay? If the obligation to maintain those windows and repair and replace those windows is on the unit owners, then those windows, those impact windows that you want to install, cannot be done unless a majority of the unit owners vote in favor of it. So you have to know what the governing documents say, but there's no harm in contacting the board and say, hey, I just did it, and I'd like to do it, for everybody in the building. You can do that. It's First Amendment right to do that, no problem. Yeah. But they may tell you, hey, buddy, we'd really like to work with you, but since the documents don't make the windows a requirement of the board to install, then it's not our decision. It's a decision of the community. Okay? James, I hope that answers your question. Donna in Green Acres. How are you, Donna?
Hello.
Hey, how are you, Donna? How can we help?
I'm okay, I guess. We we live in townhomes, and we're all in an uproar right now. It's a combination question. They are assessing every homeowner $6,000 and wanting a $2,000 down by February 15th, and then $1,000 per month after that. And however, the reason they're doing this assessment is for roofs, but nobody voted. The homeowners did not vote on getting 16 buildings roofs done, which they would be a fourplex. What can we do?
How tall, when you say townhomes, how tall are your townhomes? How many stories?
2-story.
2 stories. You know what my advice to you is? I'm saying this sincerely. Karen, as long as you know that if it's under 3 stories, the new laws don't apply to you.
That's right. Right.
So don't complain. That's about the best I can put it.
Yeah.
And I mean this sincerely.
Yeah.
If the board determines, right, and it's up to the board, I know you're saying, we never voted on a new roof. That's not your job to vote on a new roof.
Yeah, they must have found there was major problems.
Right. If everybody got to vote, nothing would ever get fixed in a condominium.
Couldn't they get a loan? I mean, that seems
Absolutely.
that seems cumbersome.
And that's what's happening now. So oftentimes now, instead of assessing the unit owners $6,000 basically in one shot, a lot of boards are saying, well, let's take out a loan, so that everybody will basically wind up getting 2 years.
And in Miami-Dade, they pay you $30,000 each, right?
Where are you?
She's in Green Acres.
That's like Broward or Palm Beach County, right?
However, Eric, we already have an SBA loan, and we get a letter that says if you do not pay this money by the 15th, we will charge you a late fee and attorney fees, and we will put a lien on your home, and then we will take the title to
So the bottom line is you already have a bank loan?
Yeah, they already have one.
Okay, so maybe, I don't know if you already reached your credit limit.
Oh.
I have no idea if you already borrowed as much as you can borrow. I have no idea. But the important part about this question, the question that you asked, is that when it comes to repairs, right, that decision is made by the board of directors, not the unit owners. And the board members are all protected by what's called the Florida Business Judgment Rule. If anybody were to take this to court and say, we don't need a new roof, you know what the judge would have to say? Sorry, I can't hear your argument because the board members are all protected by the Florida Business Judgment Rule. It's not the role of a court to determine whether or not the repairs do need to be made. They're going to leave that up always, 100% of the time, They're going to leave that up to the discretion of the board of directors. And when it comes to the special assessment, unless there's something in your governing documents, and I don't even know if that would hold up, you need these repairs, bottom line, and it's up to the board to determine how the special assessment will go down. They're giving you a few months to do it. They could have asked it for you in one shot.
Yeah.
They're asking for $2,000 by the 15th of February, then $1,000 on the 15th of each month.
But they could have asked for $6,000
Right.
all
They
upfront.
could have asked you for $6,000 on February 15th.
The people in the Champlain Towers needed to come up with
$100,000.
$100,000.
And then they're threatening to put people out on
That's
the
how it
street
works.
by
And
taking their title to their home.
and they will.
Yeah.
And I'm guessing it's because the roof situation is very, very urgent.
Yeah.
And they don't want, serious damage occurring to the building because they failed to fix the roof. So, again, if I was a judge, I have to yield to their discretion on that.
Then.
Okay? So I hope that answers your
Are we
question.
SOL basically?
Yeah, there's nothing you can do. Correct.
The bill has come due.
The bill has come due. You got it. Armando in the Florida Keys.
Oh, Armando.
How are you, Armando?
Good morning, guys. Thanks for taking my call.
Sure thing. What's up?
Question. Last week's show, did I hear correctly that somebody mentioned that the right to inspect documents statute was moved from 718?
No. No. Both statutes still allow, in a condo and an HOA, you're still allowed to inspect documents. I think what you might be referring to is in 718, at least there used to be something where a unit owner can send in what's called a unit owner inquiry, right? Basically a question, and the association had to answer the question. I don't see that in the statute anymore. But in both statutes, you can still get access to records. In a condo, you got to ask for it in writing. In an HOA, you must send it certified mail, return receipt requested. Does that answer your question?
Excellent. I have a follow-up.
Sure.
We filed a complaint with DBPR because we made the request via certified mail, return receipt, and the board refused to provide access to those documents.
Okay.
Like I said, we filed a complaint with DBPR, and the inspector has been assigned to it, but nothing has happened. And this dates back to September 2022.
Yeah, they are backlogged with thousands of complaints. I can tell you, under the statute, if you can show that you asked for it twice, they have the right to now issue a subpoena.
Whoa.
They can actually issue a subpoena to the association requiring them to turn over the records. So maybe you want to follow up to them and say, hey, why aren't you issuing a subpoena to the association to turn over the records? Okay? One bit of advice. Ask them to serve a subpoena on the association. Okay?
If you ask twice.
Yeah, you got to show that you asked twice from the association, okay?
Okay.
All right, Armando. How about we got a Naomi in Del Rey? Naomi.
Hello?
Yes,
Hey.
Naomi there.
Naomi, thank you. Yes, thank you for taking my call.
Sure.
You just mentioned to somebody asking the question that painting the clubhouse in a condo is a material alteration needs members voting, correct?
Yes.
And if painting the residential buildings in a condo, that would be also material alteration.
If it's
correct?
painted a
Changing
different
the
color,
color.
yes. If it's painted a different color, yes.
Yeah, because my condo is doing it, but they did not have any voting. They just decided.
Why
and
is this?
so
Why is this
that's-
still a problem? You know.
I don't know.
You know, I don't get it. You know, this is
That-
when
they-
board
no,
members don't get
they have to
educated.
take your education
Yeah, this is when
course.
board members don't get
Exactly.
educated. You know.
Yeah, I have another quick question. They removed all the bulletin boards by the mailboxes because they say Zoom meetings and electronic and everything, and they are not posting notices in conspicuous places,
Right.
In the community.
Right.
Is that okay?
Of course not. Absolutely not. You know that if they're going to have a meeting, they got to post notice of that meeting in a conspicuous place, right? At least 48 hours in advance 14 days in advance if it's going to be a unit owners meeting. So they are clearly in violation.
Okay. And, okay, another question. We voted last year to combine the reserves. And does it have to be done every year since we vote for reserves every year?
No.
Forever
No,
combined?
absolutely not. I understand what you're saying. You voted to have the reserves instead of line item reserves. You decided to have the pardon, my brain is blank. You decided to combine your reserves in one. Pooling reserves. Thank you, Karen. Yeah, decided to have pooling reserves, which I can tell you it's my interpretation of the new statute that when, at least for the structural integrity reserve items that you're going to be required to reserve for, all those 10 items that all of you better get ready to reserve for, I don't believe that you're going to be able to pool for those items the way I interpret the statute, but we'll see.
Yeah.
But everybody better get ready for those 10.
Yeah. Our condos are no more than 2 stories. So does the mandatory reserve apply to
Oh,
us?
it does not sleep well.
Yeah. Good for you.
You live in a friendly place right now. You live in a friendly place right now. All of those new laws don't apply to you, so you're lucky. Okay.
So it does not apply to us.
Correct.
Full mandatory.
I can tell you that townhomes and condos that are 2 stories or less, man, those are going to be hot items on the market. That I can tell you. Guys, I just got that whisper in my ear that there's 30 seconds left. If you need legal help off the air, and I think so many of you do.
I do think so.
Right?
Give
Cole
them a
Glazer and
number.
Sachs, thank you. Cole Glazer and Sachs, 954-983-1112. Again, 954-983-1112 during the week. And
your seminar in Broward is on February 7th.
Seminar in Broward is coming up. Register
February
at Condo,
7th.
Craze, and HOAs.com. Everybody have a wonderful, safe week, and we'll speak to you again next Sunday at 11 a.m. Be well, everyone.